Welcome to the Deep Dive, where we cut through the noise, make sense of complex info, and really unearth those crucial insights hidden inside. Today, we're plunging into a South African legal battle, one that grapples with a profoundly human question. When, in the eyes of the law, does a person truly begin to exist, especially when it comes to claiming for harm?
It's a fascinating question, isn't it? It touches on medical understanding, ethical considerations, and the very foundation of justice itself. Our focus today is a landmark 2005 judgment. It's from the South African Supreme Court of Appeal, Road Accident Fund v. Mtati.
Right, Mtati. We're going to navigate how South African law evolved, how it addressed the incredibly sensitive issue of prenatal injuries. We'll explore the core legal ideas, the arguments from, both sides, the court's powerful reasoning, and importantly, why this case is still so significant for you, whether you're maybe a law student knee-deep in delict, or just really curious about how legal systems adapt to ensure fairness.
Exactly. Our mission really is to make this engaging, make it crystal clear. We want to show how courts have to balance these deeply rooted legal traditions, these fictions sometimes, with modern ideas of accountability, and ultimately striving to ensure the law delivers, well, comprehensive justice.
Okay, let's start with the human story. The story that ignited this whole legal firestorm. Picture East London, December 1989. A motor vehicle, driven negligently, sadly collides with a pedestrian.
A terrible event, yes. But here's the crucial part. This pedestrian, she's pregnant with her daughter, Zukanya. And as a direct result of that collision, the mother sustained serious bodily injuries. So this wasn't just about the immediate victim. It really set the stage for a much bigger legal question.
Fast forward about 5.5 months, Zukanya is born. But tragically, she comes into the world with brain damage and mental retardation. And the family believe, they alleged in court, that these severe conditions were a direct consequence of the injuries her mother suffered in that collision months before she was born.
That's right. So Zukanyi's father, Mxolisi Richard Mtati, initiated a claim. He did this against the Road Accident Fund, the RAF, for over R1.3 million on his daughter's behalf. And this wasn't just about the money. It was really a demand for recognition of a profound wrong.
Okay, so this is where it gets legally complex, right? Because the RAF didn't just roll over and accept the claim. They raised what's known in law as a special plea, which is basically a procedural way to say, hold on a second, there are fundamental legal reasons why this claim just can't proceed. Forget the facts for a moment.
Precisely. Their argument, it rested on two main points. First was a very strict reading of the law at the time, Article 40 of the Multilateral Motor Vehicle Accidents Fund Act. It's the predecessor to the current RAF Act. Now, this article says the fund must compensate a person for bodily injury. The RAF argued that at the moment of the collision, Zukanya was a fetus in utero, an unborn child, and therefore, crucially, not a person entitled to compensation under that specific act.
Okay, so if you're not legally a person, when the bad thing happens, you can't claim. Simple as that, in their view. What was the second point?
The second point built directly on the first. They argued, well, if a fetus isn't legally a person, then the negligent driver couldn't possibly have owed a duty of care to Zukanya at the time of the collision.
Ah, right. It's like saying you can't owe a legal duty to someone who doesn't legally exist yet in the eyes of the statute.
Exactly. For a legal duty to exist, there has to be a legal entity, a person, to whom that duty is owed. So in the RAF's interpretation, without Zukanya being a person then, the whole basis for a claim, it just crumbled.
So what the RAF was essentially arguing was that Zukanya, even though she was born alive with these terrible injuries, allegedly from the accident, had no legal standing, no protection from this specific harm because she wasn't technically born yet when the collision happened. It really shows how these legal definitions can create huge real-world barriers.
Absolutely. And to really get the weight of this, we need to look back. We need to talk about an earlier, really critical case in South African law, Pension and another NOV Santam Insurance Co. Ltd. That was back in 1963.
Pension. Right. I remember that one. Didn't it set a kind of precedent here?
It did, although a contested one. In Pension, the High Court, specifically Heimstra J presiding, made a really bold ruling for the time. He said a child could claim damages for injuries sustained before birth.
Which was pretty forward-thinking for 1963. How did he justify that?
He used a principle from Roman law. It's called the Nasciturus fiction.
The Nasciturus fiction. Okay, what's that?
It's a legal fiction, basically. It says that an unborn child, provided they are later born alive, is treated as if they already existed whenever doing so is to their advantage. It's a sort of legal time travel, retroactively giving rights to protect the child's interests, usually in things like inheritance.
Okay, so it's like pretending the baby was already there if it helps them. But Hamster J applied it to injuries,
Oh.
to delict.
Yes, that was the big step. He explicitly said, and I'm quoting roughly here, there is apparently no reason to limit this rule and exclude it from the law of delict. He even kind of sidestepped the whole person debate. He said the word person wasn't defined anyway, so whether the fetus is a person or not seems to me to be irrelevant if the legal fiction applies. Pretty bold.
Wow. But did the higher courts agree with him back then?
Well, that's the wrinkle. The appellate court in Pynchon didn't actually make a final ruling on that specific legal point. They found there wasn't enough proof that the accident actually caused the child's cerebral palsy in that case. But despite that, Hamster J's reasonings, it had a huge impact. It was cited positively in Australian courts, English courts, discussed all over in legal journals. It really put the idea out there.
Okay, so fast forward back to Mtati. The High Court, now with Frohman and Jay, has this Pynchon precedent sort of hanging there, and the RAF pushing back hard.
Yeah.
How did Frohman and Jay handle it?
Frohman and Jay essentially followed Pynchon. He accepted Hamster J's decision as correct and applied that Nasciturus rule to Zucania's situation. He also took a broader view of the RAF Act itself, calling it social legislation aimed at the widest possible protection and compensation. He used that idea to support applying the fiction.
And what about the RAF's argument about the ordinary meaning of person? Did he buy that?
No, he rejected that pretty firmly. He emphasized that context is all when you interpret legal words. A very modern approach, actually, meaning you look at the purpose of the law, not just the dictionary definition.
Right, the purpose here being compensation for road accident victims.
Exactly. And interestingly, he also dismissed the classic floodgates of litigation argument, the fear that allowing this kind of claim would open the door to too many lawsuits. He concluded that, yes, a duty of care could be owed to a fetus. So the High Court sided with the Mtati family.
But the RAF, they weren't done yet, were they? They took it higher.
They did. They appealed to the Supreme Court of Appeal, the SCA, and they basically reiterated their main arguments.
Sticking to their guns about the ordinary meaning of person.
Yes. Their lawyers argued the High Court messed up by not sticking to that literal meaning. They pointed to other laws where person specifically excluded unborn children, arguing for consistency.
And the floodgates argument came back too.
Oh, yes. Strongly. They argued that stretching the common law like this could lead to an uncontrolled right to claim damages. They even pointed to the UK's specific law, the Congenital Disabilities Act, saying, look, if you want to do this, Parliament should do it carefully with proper limits, like maybe rules about suing the mother, which courts can't easily invent.
So their line was, this is too complex, too potentially messy, leave it to Parliament.
That was the core message. Yes, let the legislature handle it.
Okay, so what was the counter-argument from the Mtati family's side in the SCA? Did they just rely on Pynchon again?
They definitely argued Frohman J was right to follow Pynchon and use the Nasciturus rule. That was their primary stance. But they also introduced a really interesting alternative argument, one championed by the late great Professor W.A. Joubert.
Ugh. What was Joubert's idea?
Joubert suggested maybe we don't need the Nasciturus fiction at all here. He argued it was an artificial extension of the rule. Instead, he said, the answer lies just in the ordinary principles of delictual liability, the basic rules about causing harm and being responsible for it.
Ordinary principles.
Yeah.
How would that work if the child wasn't a person when the negligence happened?
See, Joubert's genius was to reframe the question. He said the claim isn't for damage suffered while a fetus. The claim is for damage suffered by the living, born person. The act that caused the harm happened before birth. He argued that's irrelevant. Think of his analogy, a time bomb.
The time bomb analogy.
If someone plants a bomb before you're born, but it only goes off and hurts you after you're born, you clearly have a claim against the person who planted it.
So the focus shifts from the moment of the negligent act to the moment the damage actually manifests in a living person.
Exactly. It's when the harm lands on a legal subject. And this idea wasn't totally out of the blue. There were supportive international cases, like a German case where a child got syphilis because the mother was infected before conception even happened, due to hospital negligence. The child successfully sued.
Wow. Before conception. The Nasciturus fiction definitely couldn't help there, could it? It relies on the child already being conceived.
Precisely. It showed the limits of the fiction. Joubert's approach seemed more flexible, more grounded in just, cause and effect leading to harm in a person.
Okay, so the SCA has these three paths.
Yeah.
Stick with the Nasciturus fiction, Pynchon, Except the RAF's strict no person, no claim view or adopt Joubert's ordinary principles approach. Which way did they go?
The judgment, written by Farlam J.A., was incredibly clear. He started by saying, quite powerfully, that it would be intolerable if our law did not grant such an action, full stop. He borrowed from a Canadian case, Montreal Tramways, quoting Justice Lamont. If a child after birth has no right of action for prenatal injuries, we have a wrong inflicted for which there is no remedy. He stressed it was natural justice for the child born alive to have a claim.
That Montreal Tramways case keeps popping up. You mentioned earlier it caused a huge shift in American law, too.
It really did. It was massively influential. So Farlam J.A. is tapping into this global recognition that there has to be a remedy here. Then he tackles the core issue. Nasciturus fiction versus ordinary principles. He acknowledges the Canadian judges were split too, but he comes down clearly in favor of the ordinary principles of delict approach, very much aligning with Joubert and some of the Canadian reasoning.
Okay, so he formally moves away from the Nasciturus fiction for these kinds of injury claims. What were his main reasons for doing that? You mentioned the preconception issue.
That was a big one, yes. The fiction offered no solution for cases like that German syphilis example. Farlam J.A. said those cases cry out for a remedy, and any theory that denies one just shouldn't be accepted. It fails a basic test of justice.
Makes sense. What else?
He also pointed to what he saw as an unjust result caused by the fiction in another South African case, Stevenson NO v Transvaal Provincial Administration.
Stevenson. What happened there?
In that case, a child was born after the father died due to someone else's negligence. The child had a claim for loss of support. But because the Nasciturus fiction pretends the child existed at the time of the father's death, before birth, the court said the legal right to sue, the cause of action, arose then. And because the claim was filed later, it was outside the time limit, the prescription period. The claim failed purely because of the fiction's timing effect.
So the fiction, designed to help the child, actually ended up barring the claim.
Exactly. Farlam J.A. explicitly disagreed with that earlier ruling's reasoning. He said, in his view, no cause of action arose until Stevenson's posthumous child was born.
So the right to sue only clicks into existence when the child is born alive and can suffer the loss or damage as a legal person. That is a crucial distinction.
It really is. It links back to that English judge's quote you mentioned, Justice Phillips. In law and in logic, no damage can have been caused to the plaintiff before the plaintiff existed. The damage is suffered at the moment of birth when the child inherits that damaged body or situation.
It's much cleaner legally, isn't it? Focus on the manifestation of damage in a legal person.
It avoids those logical knots, yes. It focuses on reality. Harm occurs, a person is born, that person suffers the harm, therefore they should have a claim.
And what about the RAF's other big argument, the duty of care point? If the child isn't a person at the time of the crash, how can the driver owe them a duty?
Farlam J.A. shot that down pretty decisively, too. He again quoted a Canadian judge, Fraser J. and Duval v. Seguin. The reasoning was simple common sense, really. Drivers must foresee other road users. Pregnant women are foreseeable road users. Therefore, drivers must foresee that their negligence could harm a fetus the woman is carrying.
So the duty is owed to the world at large, including potentially pregnant women and their unborn children.
Essentially, yes. The potential for harming a child en ventre sa mère in the mother's womb is a foreseeable consequence of negligent driving. The duty exists.
Okay, that deals with the duty. But what about those floodgates? Did the SCA worry about opening the door to all sorts of claims, like the RAF feared?
Farlam J.A. addressed it directly. He acknowledged the concerns, especially looking at some issues in the U.S., like claims for stillborn children or children suing their own mothers for lifestyle choices during pregnancy. But he explained why those specific problems were less likely to blow up in South African law under this ordinary principles approach.
Right, you mentioned there were specific reasons. What were they?
4 main points. 1, the right to sue only becomes complete when the child is born alive. That immediately cuts off claims for stillbirths under this specific delictual action. 2, if the child dies very soon after birth, claims for things like pain and suffering generally lapse unless litigation is already well underway, so limited scope there too.
Okay, born alive is key. What else?
3, South African law generally doesn't allow big claims for lost years of life, the income someone might have earned if they hadn't died prematurely. That limits damages compared to some other places. And 4, the really tricky one, claims against the child's own mother. Farlam J.A. said such a claim would only work if a specific legal duty was recognized between mother and fetus in that context. He explicitly left that question open for another day, saying the court wasn't deciding that now.
Smart. So they addressed the fear, but limited the immediate scope, focusing only on the case before them, a third party's negligence, injuring a fetus who was later born alive.
Precisely. They calmed the fears by highlighting existing legal controls and deliberately avoided making rulings on more complex hypothetical scenarios.
So after navigating all that history, all those arguments, the fictions, the principles, what was the final word from the Supreme Court of Appeal?
The SCA upheld the High Court's decision. They ruled that the special plea raised by the Road Accident Fund was correctly dismissed in the first place.
Meaning the RAF's appeal failed. And Zukanya Mtati, through her father, could finally proceed with her claim for damages against the fund.
A clear victory, yes. And a landmark moment for South African law concerning prenatal injuries.
What an incredible journey through such a complex, but wow, hugely important area of law. Road Accident Fund v. Mtati really stands out.
It absolutely does. It cemented the right of a child born alive to claim for prenatal injuries. But crucially, it did so by choosing a more modern, pragmatic legal path, the ordinary principles of delict, over sticking rigidly to that old Nasciturus fiction.
It feels like a victory for that idea of natural justice, Farlam J.A. mentioned.
Yeah.
Making sure people don't have to, as you quoted, go through life carrying the seal of another's fault without any recourse.
Yes, and establishing that key principle, your legal rights regarding an injury can crystallize at birth, even if the harmful act itself happened before you were technically a legal person.
It really shows how law isn't static, how it has to adapt to our understanding of, well, everything, medicine, fairness, causation, to provide remedies where they just feel necessary.
It's a constant evolution, trying to achieve justice in changing circumstances.
So for you, our listener, maybe something to think about. If the Nasciturus fiction, this long-standing legal tool, proved too rigid here, where else in the law might we find similar fictions or old rules? Are there other areas we're focusing on when harm actually manifests in a living person, rather than relying on historical legal constructs might lead to, well, more just outcomes? Where else might we find situations that, as Farlam J. put it, cry out for a remedy?
That's a great question. It suggests the law's work is never quite done, is it? Always catching up, refining, trying to get it right.
Absolutely. And that wraps up this deep dive. Thank you so much for joining us. We hope you're leaving feeling a bit more informed, maybe a little clearer on how these complex legal ideas work in practice.
And maybe even a bit inspired by that ongoing search for justice within the legal system. Until next time, keep digging, keep asking questions.
And keep learning. Bye for now.